You're darn right they're looking at your old visa applications. Hi, I'm Jim Hacking, immigration lawyer practicing law throughout the United States out of our offices in St. Louis, San Diego, and Washington, D.C. When I first started practicing immigration law back in 2008, 2009, it was very, very uncommon for a USCIS officer to have the ability to go back and check what someone said to an immigration officer at the U.S. consulates abroad when they obtained their visit visas. It was very unusual for USCIS to have instant access to the DS-160 applications, to the consular officials' interview notes. When an officer wanted to get those things, they had to formally request them. It was a long, drawn-out process. And so sometimes you would go to an interview back then and you'd have two interviews. You'd have the initial interview, and then some issue would come up at the interview involving the prior application by the person sitting in front of them trying to get a green card based on marriage or asylum or employment. And the officer, for whatever reason, was triggered and needed to make a formal request to the State Department to go back and obtain those notes and obtain that DS-160, because what they're looking for is a reason to deny the green card case. So everyone thinks, oh, that was in the past. Oh, I married a U.S. citizen. Oh, everything is going to be fine. Oh, I don't need to worry about whatever it is that I said to get into this country. And so back then it was really hard. The officer would wait 2 months, 3 months, and sometimes your interviews would get rescheduled because they were wanting to drill down and find out what you said when you got your visit visa. They wanted to see if everything you said was true. And so because it was so much harder for officers to get that information, denials based on things that you said back at your embassy interview were much rarer. They hardly ever happened. It was very unusual to get a notice of intent to deny or an actual denial from USCIS because of things that somebody said in a visit visa. It happened, but it was only, like I said, after that drawn-out process where they went ahead and got the old file from the State Department. But you know what? In the last couple of years, it's become instantaneous. They have instant access to whatever it is you said at your DS-160 interview, to whatever you put into your DS-160 form, to whatever you told the CBP official when you came on your visit visa or your student visa or any other kind of visa. We're really seeing the ability of these agencies to really talk to each other and to use that information right then and there in the interview. So I don't know technologically how it works. I just know that we've gone from one extreme to the other where it was very, very hard for them to have that information to now it's very, very easy. Why is this important to you? The reason this is important is because when I think about a case now, when I look at a case, when I try to see whether or not I think someone's going to be able to get a marriage-based green card, I always go back to the beginning. If you watch my Immigration Answers show, you'll see that I always start with, how did you enter? How did you come? What was the purpose of your visit? Did you fulfill the purpose of that visit? Did you say anything that was untrue? Did you embellish? Did you say that you were a rock star engineer? Did you say you were coming for a super high conference and instead you just went to work at your cousin's pizzeria? These are the kinds of things where they're going to compare what you said and what you did. They're going to see when you landed in the United States, where did you go? When you came, how soon did you start working? When did you first violate the terms of your non-immigrant visa? Because a lot of times these will be people who are applying for adjustment many years after those initial entries, many years after whatever misrepresentations they made. They think they're well past any consequences for that, but it always comes back to the beginning. It always comes back to haunt them. Now, some people get away with stuff, I'm sure, but in the vast majority of cases, USCIS has gotten much better at figuring out what exactly you said and what exactly you did and comparing them. I've seen them look at the addresses that you put on your I-45 and say, well, that you said on your 45 that you were living back when you first came in New York City. And now when we look back at the notes from your consular official interview, it said you were going to Oklahoma. What's the deal? Why'd you go to New York and not to Oklahoma? Oh, you moved in with your cousin. Oh, I see. And you sold those red tickets for people to get on the red buses. That's what you're doing? I thought you were coming to study, or I thought you were coming to visit your grandmama in Oklahoma. But lo and behold, when we compare what you said and what you did, they're two different things. So I think you made a misrepresentation. I think that I can't approve this green card unless you get a waiver. And then you're talking about a whole new set of applications, a whole new set of evidence, a whole much more expensive process, a much slower process. And so I really want you to understand that whatever you told the consular official or whatever you put into that DS-160, a lot of people like to say, oh, I hired this consultant and they told me to say that I was married when I wasn't. Or I told the consultant that I was coming for a conference and they said, well, we got to tell them you have a PhD when you don't really have a PhD. These consultants around the embassies really give someone what I call a poison pill. They might get them into the United States, but it's going to make it much harder for them to ever get any substantive immigrant benefits like a green card because of false things that they were either coached to say when they went to the interview or coached to put into their DS-160, or it was actually completed by them and the person just signed it. They're like, I just signed it. It wasn't my fault. Well, guess what? No one knows where that consultant is right now, and the consultant isn't the one trying to get a green card. It's you who's trying to get a green card, and it's you who's going to bear the brunt of these misrepresentations or embellishments or lies or falsehoods or tricks that you played on the State Department to get your butt into the United States, and now you're going to have to explain that or perhaps need a waiver. And so these are much harder times. They're definitely looking for reasons to deny you, and one of the easiest ways to do it is by showing that you lied your way into the United States. Lying your way into the United States never pays. All right, so if you have questions, if you want to get started on a green card and you're worried about what you said in your DS-160, give us a call at 314-961-8200. Email us info@hackingimmigrationlaw.com. Be sure to join us in our Facebook group. It's called Immigrant Home. We'd love to have you join us there. There's thousands of people talking about the immigration process every day. And they also follow us on YouTube. That's our YouTube channel, Hacking Immigration Law. You can follow us. And you can subscribe to the channel, and you can also text the word SHOW, S-H-O-W, to come onto our Immigration Answers live show and ask me an immigration question or ask me about your case. We'll go from there. Finally, if you're not following us on TikTok, I suggest that you do at Immigration Hacking. Thanks so much, and we'll see you on the next video.